Okay, this is our continuation of part 2 in chapter 3. Continuing for residency and aptitude tests. Aptitude testing. Employers must justify the use of the test by showing it is job related and for the sole purpose of identifying qualified applicants. So the tests that employers use have to be directly correlated to the job that they're supposed to be testing for. And that's got to be demonstratable. Everything is verification based. You got to be able to prove and show a reason for doing everything. If the test is used as a pretext to disqualify members of a protected class, then the employer's action is discriminatory. Okay. So that's basically the underlying point. If they use a test that can be shown to discriminate against a protected class, a demographic of person, marginalized demographic of person, then that is grounds for discrimination. Next, residency requirements. Cities, towns, counties, and municipalities may require that applicants for civil service positions be residents. This mandate or preference must be clearly stated in a local ordinance. Okay, so they give a little brief overview. Residency requirements may not be instituted by state/local governments unless implemented to alleviate loss of economic benefits or the state's high unemployment. Next, physical and skills test. Physical tests may be used in jobs requiring certain physical attributes such as strength, dexterity, quickness, and endurance. Skill tests may be required for typists, legal stenographers, electricians, carpenters, and plumbers, as long as tests mimics the actual work performed. Next is personality and integrity tests. Personality tests determine the character traits essential for a particular job, such as aggressive, outgoing, persistent, and they must satisfy Title VII's requirements of business necessity. Integrity tests are designed to identify individuals who have a propensity to steal. Okay. Next section. Honesty and psychological testing. Honesty testing, usually referred to as lie detector tests, i.e. polygraphs, voice stress analyzers, and stress evaluators. Psychological testing. This may be administered only when the employer can show a compelling need. I would imagine that this might be for, let's say you're in human resources with the state. You might work with state police. To become a certain type of law enforcement, certain type of job, maybe dealing with at-risk populations. So let's say you're working with at-risk women. You know, they might do a psychological test to make sure you don't have any implicit bias, or you might not be a danger or a threat. You know, if you're working with displaced children, children of the wards of the state, such as that, where you'll have a significant absolute authority over these people's lives, maybe correction officers, things like that, parole, probation. I would assume, or I would hope, that there's a degree or measure of psychological testing, making sure that these people placed in these positions of authority are safe to be there. Okay, so that's what that's stating. All right, the next category is medical exams. Medical exams may be given when an applicant is given a conditional offer of employment. Okay, so after you are offered, or after an employee has been made an offer, or potential employee applicant has been made an offer, then a medical exam may be given. Medical inquiries made prior to a conditional job offer are in violation of the ADA Act. So we talked about this. We want to make sure that we have a great understanding of the ADA. So far, in every business management and HR related course that I've taken, they've mentioned the ADA. So I would, I'm plainly saying I would know about it. American Disability Act. Off the top, it's important. It affects things you wouldn't think of. I saw it in my, if you look here, I have a repertoire of books. They talked about it in my electrical book. I worked, getting on a quick tangent, some of my background, I worked as an electrician under the expert tutelage of a 50-year master electrician, 50-year master electrician. And we covered the ADA and how certain, in relation to wheelchair ramps, but specifically for us, for outlet and light switch placing. So it's got to be basically within reach for someone that's in a chair that they can access it, So you're going to see the ADA everywhere, If I can see it in construction, in my electrical construction, that just tells you it's a big thing. All right, getting back to this HR. Okay, so medical exams should be required of all new employees and designed to determine whether the individual is fit to perform the job. Getting my piles confused. This one, here we go. So we're at 3. All right. Next is polygraph tests. Polygraphs are a form of lie detector test. Its use is prohibited in all but a select set of instances because reliability is questionable and amounts to an invasion of privacy. Employee Polygraph Protection Act of 1988. The EPPA applies to all employers engaged in commerce. It does not apply to the federal, state, or local government. A polygraph test can be administered to an employee if the employer has reasonable suspicion that the employee was involved in theft of property or information. That's something for people to know that work for federal, state, or local government. They can be polygraph tested if they think you're stealing. Okay. So next we move on to drug testing. Employees using drugs are less productive. Employers want and are permitted to safeguard their businesses against those who abuse drugs and could jeopardize the company's safety. Many companies increase supervision, create drug rehabilitation programs, advocate a drug-free work environment, and test for drugs. The Fourth Amendment affords individuals the right to be secure in their person, property, and effects. Individuals do not have to submit to unreasonable searches and seizures. Okay, so these two are related. And I'm thinking that they're going to tie in on maybe a possible employee that you suspect or that management suspects might be abusing drugs. The Fourth Amendment and how far it extends to their ability to be searched or not to be searched on the premises. So we'll backtrack and go over this one more time. With drug testing, many companies increase supervision, create drug rehabilitation programs, advocate a drug-free work environment, and test for drugs. They don't want you using drugs. They care. Employers care. The Fourth Amendment. The Fourth Amendment affords individuals the right to be secure in their person, property, and effects. Individuals do not have to submit to unreasonable searches and seizures. This is the argument against drug testing, stating it infringes on our Fourth Amendment rights. Okay, so one thing I want to mention too now, I'd be curious to see how, now that marijuana is legal in a lot of states, and a lot of people are prescribed and use it as a way to treat holistically anxiety, PTSD, stress, and numerous amounts of mental health related issues, and now it's more mainstream. How that is going to affect HR in the workplace moving forward. as it becomes more and more mainstream. So that's something I'll probably look into on my own and report back to you guys, for those that care about the changing and evolving world of HR. All right. So we're getting towards the end. Reasonable suspicion and drug testing. Suspicion-based drug testing requires an employer have a reasonable suspicion that the employee is using drugs before a drug test can be required. Suspicion-based drug testing may be done anytime during employment if the reasonable suspicion requirements are met, i.e., caught selling drugs, using illegal drugs, possession of drugs/alcohols at work, etc. Suspicionless drug testing, aka random. In 1989, the U.S. Supreme Court legitimized suspicionless drug testing for two distinct classes of workers: railroad employees involved in accidents or who violated safety regulations, and custom agents carrying firearms or detecting drug smuggling. That's also very interesting to know. Custom agents, random drug tests. Okay, so the Drug-Free Workplace Act. The employer must publish a conspicuous notice in the workplace that drug use is prohibited. Notice must be sent to all employees. Must educate employees about the dangers of drug use and availability of counseling/drug treatment facilities. Consequences of using drugs and or not seeking voluntary treatment. Okay. Next is job relatedness. Oh, feel a sneeze. Extra! Excuse me. Job relatedness. Fourth Amendment requires the reason for drug testing be significantly job related. Must show it would affect public safety, national security, or the safety/security of the workforce. Okay. All right. We're getting to our closing sections. Last section is lab testing. Examinations of blood, saliva, and hair are alternate methods to urine and drug samples. Collection is said to be less intrusive, but they provide much more detailed info. Marijuana or weed accounts for most drug use found during testing, but cocaine and heroin are also frequently identified. Testing procedure and drug treatment. A drug test is not a medical exam, so it can be given prior to employment. Employees who are enrolled in an alcohol/drug treatment program are protected under the ADA. Current drug users are not. Illegal use of drugs or alcohol is grounds for termination. Okay, so our summary. The employer's need to know is at odds with the employee's privacy concern. Courts often require an employer to establish a need for information to overrule an invasion of privacy. Employers can reduce hostility and build trust by sharing concerns that drove them to the implemented test. It's not always what you say or do, but how you say or do it. All right? And that's our closing. So, if anybody wants in the comments, if you got any questions about any testing, drug testing, or anything like that, these are all big topics that they're going to stand out that you should be familiar with in the field of HR. If you've got anything that relates to it, or the ADA Act, you're also working in construction and you came across it, shout me out, say something. Yeah, I appreciate you watching. So, our next video will be Chapter 4, and we're going to cover privacy, theft, and whistleblowing. And that is Employment Law, New Challenges in the Business Environment by Moran.